Okay, so tonight we're talking about foreclosure and what happens uh, when an apartment building gets foreclosed, what that means for tenants. And it involves both risks and opportunities. And the context we're in right now is that there seems to be a wave of multi-unit foreclosures building. Uh, that we last saw after the financial crash back in 2008 to 2010. And there are some lessons that we learned that time around that we can make use of now. Everything from making sure that repairs get done to possibly even ways to move the ownership of buildings over to preservation purchasers, someone who will buy it and keep it affordable. So I'm going to go over, this is just sort of an intro to all of that. Um, we're going to talk some about the legal foreclosure process, which is a pretty complicated process in itself. So there's going to be a lot of places where we could dive deeper, but it could be worth us having further conversations where we go into different parts of it with a deeper dive. But right now, we're going to look at it, an overview of it. We're going to look at what the steps are, what happens, and what happens after that. And then also how the strategy of dealing with a bad landlord changes if the building goes into foreclosure. Okay, so I am Mike Grinthal. I'm a tenant lawyer at TakeRoot Justice. I have been a lawyer in New York City representing tenants since 2007, which means I started being a lawyer right before the financial crash. And so my learning curve as a lawyer was around working mostly in buildings where there were foreclosures and bankruptcies. Um, and so this is very much informed by the work of a lot of people back in that time. It was really a citywide effort of tenants organizing, working with organizers, working with lawyers. This is kind of a collective wisdom that I just really, really hope that we can make sure that it passes down and we don't lose it collectively. Okay, so how does a foreclosure action start? So in New York, foreclosure happens through court, which is not the case in every state. So it starts in New York by the mortgage holder filing a complaint and a summons in Supreme Court. So they start a case. The mortgage holder might be a bank, but it might also be some other entity that the mortgage has been transferred to. Um, so here on the right-hand side of the screen is a screenshot from one particular foreclosure that was started earlier this year against Ved Parkash and part of his portfolio by an entity that, as you can see there under just above the word plaintiff, is kind of an alphabet soup, right? So that is a single purpose corporation created by the mortgage holder. And so that's not unusual, and you might see it in a foreclosure where, you know that the mortgage for the building is held by a certain bank, but the plaintiff is something else entirely. That just means that the bank or the lender or whoever inherited the mortgage uh, has created kind of like a shell company to go through with the foreclosure. So the complaint has to name certain parties as defendants. Obviously, the owner and anyone else who signed the mortgage, but they also have to name anybody else who might hold a debt on the building. So for that reason, they name city agencies, Department of Finance, in case the owner owes taxes, HPD in case they owe civil penalties, the Environmental Control Board in case they owe DOB fines, etc. So the city is named in just about every foreclosure action in New York. They have a policy of only appearing in the case if the amount owed to the city is above a certain number, which I'm forgetting right now, but I think it was $30,000. So the city may or may not show up, and they may or may not be players in the case as it goes forward. And a good way to predict whether that will happen is actually to go to the Department of Finance website, look up the building, and see how much the owner owes the city. Uh, and finally, if you look at the title of the case here on the screen, at the very bottom of the title, you'll see John and Jane Doe's 1 through 50, and then a couple other placeholders. So the John and Jane Doe's, that's us. That's you. It's the tenants. The lender doesn't know the names of the tenants, but tenants have to be named because you have a property interest in the building, which is what a lease is. A tenancy is a property interest. You may also have claims against the landlord for, rent abatements or rent overcharge or anything else. So you are already defendants if there is a foreclosure against your building. In addition to being named as defendants, the law also requires the plaintiff to post this notice in a public place in the building. And this is the language in this is set by the law. The main purpose of it is to notify tenants that there's a foreclosure going on because that can affect tenancies. Not rent stabilized tenancies, not any other kind of regulated tenancies, and we'll get more into that later this evening. But the important point for us here is that this notice doesn't really treat tenants as people with agency, people who are going to act, people who might want to appear in the foreclosure, people who are in fact creditors to the landlord because the landlord owes you money. But despite this notice, you are all of those things. And it makes a lot of sense for tenants to play an active role in foreclosure cases. Okay. Once you see that notice or you get any kind of indication that there's a foreclosure going on in your building, the best thing to do is go to the court's website and look it up. And Cooper Square Committee is going to distribute copies of this PowerPoint afterwards, so don't worry about getting all these links down. But the most useful site to you in figuring out what's going on with the foreclosure is called NYSEF. That stands for New York State Courts Electronic Filing, which is for Supreme Court now and for some other courts, everything gets filed online now. And you can go online, look up the case, and you can see every single thing that's been filed. And on the right side of the screen there, that's a screenshot. That's what it looks like if you look up a case. And each of those documents there in blue is clickable, right? So if you want to see the summons, you click on number 1. If you want to see the complaint, you click on number 2, etc. It's really, really useful to be able to do this, but it does require you to create a free account with NYSEF first. So I encourage people to do that. It takes a little bit of doing, but there is a user guide on the website. You may be more familiar with eCourts, which is a place you can look up court cases without an account. The only limitation is that all you see on eCourts are the court dates, the names of the parties, and the judge. You can't look at documents there. And you are really going to want to look at the complaint because it's got the key information, like how much the landlord owes on the mortgage, and who is bringing this case and how they got a hold of the mortgage, because probably not the bank that originally lent to them. So NYSEF is a great resource. I encourage folks, if you have 30 minutes, to just click on those links and play around a little bit until you feel like comfortable enough to set up an account. And then not only that, you can also sign up for notifications so that anytime anything gets filed to a case, you'll get an email, right? Also, you can then search NICEF by the names of celebrities and find all the lawsuits that they have, which is definitely not what I do on the weekends. Okay, so once a complaint is filed, the parties have to file an answer. For folks who've been through court, maybe been through a case in housing court, the answer in Supreme Court is basically the same thing. It is just a list of the defendants, the defenses they're going to raise, any arguments they're going to make, and which facts they admit to and which facts they don't admit to. For the most part, we don't need to worry too much about what the landlord raises in their answer. It's usually just a boilerplate language. But what's important is that if you as a tenant want to appear in the case, you need to file an answer. And we're working on putting together like a template answer that tenants can use that asserts claims that you may have. So as tenants, you're unlikely to raise a defense against the foreclosure itself because obviously that's not a claim against you. But there are other claims that you might want to raise against the landlord or claims you might want to raise against the plaintiff. And that could be things such as there are conditions in the building that need repair. You should get a rent abatement because of past conditions. There's a rent overcharge. And just for terminology, when you as a defendant, and you're named as a defendant just because you're responding, you're not the one who brought the case, even though no claims are brought against you personally. When a defendant raises a claim against the plaintiff, it's called a counterclaim. And when you raise a claim against another defendant, like the landlord, it's called a cross claim. And we do have a separate workshop that really zooms in on the answer and what it takes to file an answer, what you can put in it, when you file it, etc. Like I said, we're also working on like a sample answer you can use and just fill in some blanks. But right now, we're going to move on and keep talking about the process and assume that answers have been filed. So once the answers are filed, no judge is assigned to a case in Supreme Court until somebody in the case files what's called a request for judicial intervention, an RJI, which is just a form. It's like a two-page form that somebody fills out that says, please assign this to a judge, and it gives you got to like fill in some information about the case. And then the case gets sent to a judge, and the judge can either, react to motions that people filed or have the parties come in for a conference or whatever. But if you don't see an RJI when you look the case up on NICEF, it means no judge is assigned yet and nothing will happen. Nothing can happen until there's an RJI. There's no judge to ask to do anything. Sometimes a very long time can pass between the complaint that starts the case and the RJI. That can especially happen when the owner and the plaintiff are talking about settlement. They're talking about refinancing or maybe selling the building. And so the plaintiff doesn't move forward with the case because they don't expect to really litigate it. Sometimes there's a delay because the plaintiff realizes that they don't have the right documents to actually prove their case, which happens because mortgages get transferred and passed on and on and on. And the party bringing the case might be like 3 steps, 3 degrees removed from the bank that actually had those documents. So there are, in fact, many, many foreclosure cases just sort of parked in that limbo, the shadow docket. We are going to talk about what you can do as a tenant if there's a foreclosure on your building that you want to move forward, but that's not moving forward. But I wanted to mention one other piece that you'll see, a piece of process that you'll see if you look up a case, notice of pendency. That's a notice to the world that the foreclosure is going on, right? The plaintiff files it with the county clerk, and they have to do that because if somebody new buys the building and there's no notice of pendency, then the foreclosure gets dismissed. So the notice of pendency is this is just this box that the plaintiff has to check by filing this notice, putting the world on notice that there's a foreclosure, and if anybody buys the building, they were warned and they, will step into the foreclosure. So you'll see that, it doesn't affect the building, it doesn't affect us, it doesn't really affect the case. It's just something they have to do. Once the case gets going, assuming that it does get going, that it gets assigned to a judge, usually the first thing that the plaintiff does is move for appointment of a receiver. They ask the judge to appoint a receiver. And the reason for that is that an owner who expects to lose their building no longer has any motivation to do things like make repairs and collect rent. And the plaintiff, they care about the condition of the building, not because they want it to be a good home for you, but because it's their collateral, right? They're going to get their money back from the sale of the building, and they want the building to maintain its value. So they will ask the judge to appoint a receiver to run the building while the foreclosure case is going on. The plaintiff is the one who makes that motion, but theoretically, anybody can make that motion, including the tenants. And that's something that we may find ourselves wanting to do in some cases. We should be prepared that when we do that, it will be something that a judge has never seen before. It will be something that the lawyers have never seen before, and there will probably be a lot of resistance to it. But fighting against resistance is what everybody on this call does. So they're good at it. So a motion is made. The owner can oppose it, but usually a receiver gets appointed. It's a fairly routine thing. The receiver is picked from a list of receivers that have been certified by the court. That includes some nonprofits. And then the receiver, once appointed, has to notify you that they're the receiver, that they've been appointed. And this is important because it's the receiver's responsibility to give you notice in writing that they've been appointed, how to contact them, how to pay your rent to them, and they should provide you with a copy of the court order appointing them. And that's key because right here is where the first open conflict often happens, right? So it's not uncommon for the owner to show up and start knocking on doors and say, don't listen to this guy who's going to come around and say, as a receiver, you keep paying your rent to me. And that's illegal. It's also not unheard of. I don't know if it'll happen this time, but it was a real phenomenon back in 2009, 2010. There were scammers who would monitor foreclosure cases and show up in the buildings and just start knocking on doors and say, we're the receiver, pay the rent to us, right? This can be confusing, but you can make it simple. Anybody who says, pay the rent to me, ask them, show me the court order with your name on it. And keep paying the rent to the owner, unless you're on rent strike, of course, until you see that order. Right? And if you're ever not sure, again, you can check on NICEF. And if there's an order appointing a receiver, it will be on there. And you'll be able to look at the original order with the name and the address of the receiver, right? So keep paying the rent to the owner until you see that court order. And once you see that court order, pay only to the receiver. Once a receiver is appointed, the owner is out of the picture. They cannot collect rent. They cannot bring court cases against tenants. They cannot make repairs, not that they were necessarily doing that before, And arguably, they may not even be allowed to set foot in the building. They are no longer in control of the building. The receiver is in control of the building. So a receiver stands in for the landlord. They collect rent, they renew leases, they bring eviction cases if they think it's worthwhile, and they're responsible for making repairs. But the only money a receiver typically has is what they collect in rent. So when a receiver collects rent, they actually are under orders from the court to spend that in a certain on different things in a certain order, right? So they have to first pay taxes. They even have to make payments on the mortgage. And only after that do they pay for repairs, which means that even a receiver acting in good faith is going to be really limited in the repairs they can make. And we're going to talk about that a lot this evening in a bit. But I also want to point out the receiver works for the court. They report to the judge, they get paid by the court. If they incur any expenses of a certain amount, they have to get permission from the judge. The judge is literally their boss. They report to the judge. They do not get paid out of the rent. They get paid for their time out of the money that comes from the sale of the building. So if there's a foreclosure, they get paid again by the court. They also cannot be sued except with permission of the judge in the foreclosure action. So if you want to bring an HP action, say, you can't just go to housing court. You have to go to the Supreme Court and ask permission, right? So the important thing to remember about receivers, and this is true, by the way, also of receivers that get appointed for in a 7A proceeding, they're just landlords. They're just management companies that had enough political donations to make it onto the list of approved receivers. Some are good, some are bad, some are mid, but they are landlords, right? They're not saviors. Again, some of them are nonprofits who are landlords. Nonprofits like that manage housing can sometimes get on these lists too. Okay, so once a receiver is appointed, really, you're probably starting to get the picture. Everything changes. If you've been organizing in your building already and you have done a power analysis of who holds power, what their interests are, what kind of tactics and strategies will work against the owner, everything about the power analysis now changes. The targets change, right? The building owner no longer makes much sense as a target because they can't do anything, right? They're not running the building anymore. It's the receiver who makes day-to-day decisions. So if they have to be the target in terms of any kind of day-to-day thing that you want done, and for anything that goes beyond just the routine day-to-day running of the building, remember, their boss is the judge. If you don't like the way they're running the building, or you don't like the scope of their power, or you don't like how much money they have, you have to go to their boss, and their boss is the judge. Uh, Judges have the power to actively supervise a receiver. They can literally ask a receiver to report to them on anything. They can order the receiver to appear in court and answer questions, but they're not in the habit of doing that. The general assumption by judges is I appointed a receiver to run the building. I don't run the building, right? So if you want a judge to actually act like a supervisor of a receiver, you're going to have to put pressure on them, right? And finally, the other piece of the power analysis here is the only player in this whole picture that actually has any money is the plaintiff, the mortgage holder, right? I mean, the judge doesn't have any money. The receiver has only what they collect in rent. Um, the owner might have money, but they probably wouldn't be in foreclosure if they were, if you know, if they we're liquid enough to be able to spend that money. There's one player here that has all the money, and we're going to come back to this, but if the building needs serious work beyond what the rent roll can pay for, somehow that money is going to have to be extracted from the mortgage holder. There's also a change in tactics that work, right? Ordinarily, a rent strike is one of the most powerful tactics tenants can use. Going after the landlord right where it hurts in their pocket. But a rent strike is pretty useless against a receiver. And the reason for that, as we talked about on the last slide, is that receivers don't get paid out of the rent, right? If they collect more rent, they don't get paid more. If they collect less rent, they don't get paid less. They get paid for their time by the court, regardless of whether anybody's paying rent, right? So if tenants rent strike against a receiver, the receiver is really just writing different numbers down in the rent ledger. Like it's really no skin off their back. They really, they'll bring housing court cases if they think it's worth it. But other than that, they're not moved by a rent strike. It's not their building and they don't profit from it. And all legal tactics have to go through the foreclosure, right? You either have to do them in the case with the foreclosure, or you have to go in and ask the judge's permission to go sue the receiver somewhere else. So you can kind of see how the center of gravity for just about everything is now moving into this foreclosure case. So it's most likely that the receiver, in the money that they collect each month for the rent after they pay off the taxes and the mortgage, they're gonna wind up with very little money to spend on the building, right? Um, and they're especially not going to be able to do things like capital improvements or replacements of things that have deteriorated over the years that your landlord has been neglecting the building. So, back in 2009, some tenants in the Bronx, in a huge portfolio of buildings owned by Millbank Real Estate, along with their organizers and the lawyers, came up with a new strategy. And what they did is they went to court and they asked the judge in the foreclosure to order the bank, which was Wells Fargo, to deposit money for repairs. Remember, the bank, the mortgage holder, the plaintiff, is the one with money, right? And so this particular kind of motion, people call it a Millbank motion just because that was the case where it was first used. That's just an informal name, not an official name. The judge has the power to grant that motion. They ordered Wells Fargo to deposit $2.5 million in an account for the receiver to use to make repairs, right? The judge also has the power not to grant the motion, right? Unfortunately for us, it's up to the judge's discretion, meaning they get to use their judgment. And if they don't rule the way we like, things that are in the judge's discretion, you usually can't appeal, right? So we have this tool. It is and has been a very powerful tool. It was used a lot 15 years ago, and it made a difference. It is not as good as it could be, and I'll just, as an aside, say there is a lot of room for city council or the state to pass some laws that would give tenants more tools in this situation. If the judge orders this, then the plaintiff will put some money into an account, and now the receiver will have more money to actually do good repairs, maybe to even get into the underlying causes, maybe even make some capital improvements. The bank, the mortgage holder, doesn't lose the money because when the building ultimately gets foreclosed on and sold, they just get that money back, right? And arguably, they actually in their interest because it keeps up the value of the building to actually pay for repairs. So it increases the sale price of the building. That said, that doesn't mean that a lot of banks or mortgage holders are really excited to receive millbank motions and they fight them like hell. It's often been easier to get a judge to grant a millbank motion if you can show that the plaintiff, the lender, acted irresponsibly in giving the mortgage, right? If they are a bank that gave, a risky mortgage that encourages predatory behavior, it's easier to make the case that they created the situation and now they ought to take responsibility for it. Again, tenants can only make a millbank motion if you've appeared in the case, if you filed an answer, and are a party. So there's a second way to get money for repairs, and there's just no way around it. This particular piece of the law is really convoluted, and I'm going to try to make sense. And if I don't make sense, ask questions, and I will do my best. But there is a piece of the Real Property Actions and Proceedings Law, right? Article 13, which is the New York state law that governs foreclosures. And this law, which was just amended in 2021 to be a little bit more powerful, but it's not there yet, which says that a plaintiff who starts a foreclosure case where the building has been abandoned by the owner, but there's still people living in it, the plaintiff shall, meaning they must, maintain the property until the building gets sold. They have to do repairs. That sounds great, except for the rest of this part of the law. One, which has this very intricate and convoluted definition to determine whether a building has been abandoned. And it actually requires some actions by the plaintiff. And so if the plaintiff doesn't want to get, right now, the way the law is written, the plaintiff has to take actions in order for this law to kick in. And of course, they're not going to want to take those actions. They're not going to want to go out and prove that the building is abandoned because that's going to trigger their duty to pay money. So it's a clunky law. It's difficult. We haven't really used it much because it was just developed a few years ago. It wasn't around during the last wave of foreclosures. So we don't have experience with it yet. But I think we can easily predict that calling up a bank's lawyers and saying, hey, will you go out there and do these things and post the notice so that you can get the building declared abandoned so that you have to start paying for repairs, they're not going to return our calls. In addition, even if we make that happen, the last paragraph here, the one in green, says that, even after all that, as soon as a receiver gets appointed, the plaintiff's duty to pay for repairs ends. So it's not of much help because, we really only want that duty is really only useful once the receiver gets appointed, because then there's actually somebody in place to do the repairs. So I'm putting this in there just because, we want to be resourceful. We want to use every possible law, every possible hook, every possible trigger. This is a mixed bag. It's also because it's good for us to know that there are laws out there that could be more useful for us if our elected representatives, you know, chose to amend it, right? So I'll just leave that there. Okay, so moving on with the process of a foreclosure, right? So the receiver has been appointed, the receiver has been managing the building, the litigation between the plaintiff and the owner have gone forward, the plaintiff wins, right? So there will be a judgment of foreclosure, which is usually done on the papers. There's usually not a trial because the facts are usually fairly simple, just about whether mortgage payments have been made. So there's not probably going to be any trial with witnesses or anything. It'll be done on the papers. The judge issues the judgment of foreclosure. And then they also, at the same time, issue something called an order of reference. That means they appoint basically an assessor called a referee to do the math, figure out how much is now owed to everybody, right? So that's going to include the part of the mortgage still not paid, any interest, all the legal costs from the litigation, the payment of the receiver, and then if we did a millbank motion and we won, whatever money they had to deposit, right? That is in its total how much the owner owes. And I should say, along with any other debts that they owe to the city, right? That's how much the owner owes. Then, after 21 days notice, there's an auction and the building is sold. And out of the money from the sale of the building, that big number that got calculated in the last slide gets paid. But the law establishes a pecking order, right, for who gets paid first and who winds up high and dry if they run out of money, right? So the court, unsurprisingly, court gets paid first, right? The receiver, any costs that the court itself incurred get paid off first. Second, the plaintiff, the mortgage holder, gets their mortgage principal paid off. Third, any other mortgages on the building. There usually aren't, but if there are, they come in third. Fourth is every other debt, right? So the taxes, the fines, the civil penalties, and importantly, your claims. Rent overcharge, rent abatement, any other claim you're raising against the landlord. All comes last, and those get paid off basically in order of seniority, right? The oldest one gets paid first. And then whatever's left, if there's any surplus, it goes to the owner. So we can raise claims in a foreclosure, again, for rent abatements, for not getting the full value of your apartment because of conditions, rent overcharge. But in reality, we shouldn't have high expectations about getting that money because, as in so much else in the law, tenants eat last. And again, if we're thinking about where we might want to change the system, this is one area. Okay, now finally, we've talked so far about all the different things that we can get from the foreclosure process, right? That we can get from the receiver, that we can get from the judge, that we can get from the plaintiff. This is, I want to talk about the risks that tenants face. So, some kinds of tenancies can actually be terminated by a foreclosure. Some tenants can actually lose their tenancy through no fault of their own, having done nothing wrong, just because there was a foreclosure. And in other states that don't have rent regulation, that's the norm, right? Every time there's a foreclosure, the tenants get their walk-in papers. In New York, we have better tenant laws, not as good as they should be, but better. And so many tenants are protected, right? So if you're rent stabilized or rent controlled, nothing happens to the tenancy, nothing at all. If you are part of a federally subsidized program like Section 8 or low income housing tax credit or Section 230, which is for seniors, if you're part of any of those programs, also unaffected. Nothing happens to your tenancy. If you're covered by the good cause law, things can get a little strange. I won't dive into the good cause law right now, but folks may be aware whether you're covered by good cause depends on how many housing units your landlord owns. You might be covered by good cause now, but the new owner who buys the building after foreclosure might be a smaller landlord who's not covered by good cause, or it may be the other way around. You're not covered by good cause now, but congratulations, you will be after the new owner buys the building. And that is a very strange and awkward thing that is probably an unanticipated consequence of the good cause law, something that the legislature just may not have been thinking about when they wrote the law. Everybody else. So if you have a written lease, but it's not regulated in any way, it's just a market rate lease. If it started before the foreclosure case, then your lease continues to be valid until the end, right? And then the new owner can choose to renew it or not renew it, just like any owner when you have a market rate lease. If your lease started during the foreclosure, then it's canceled by the foreclosure. So, and that can really be a problem because, as we talked about earlier, foreclosure cases sometimes sit parked in court for years, and you have no idea, people have no idea that there's a foreclosure case technically on the books, and they sign leases, and then they get the rug yanked out from under them because suddenly there's a foreclosure. And I should add, month-to-month tenants and other occupants, are always vulnerable, right? Are always subject to being evicted after 90 days notice. There is, Congress passed a law during the last foreclosure wave guaranteeing that tenants must have 90 days notice. New York already has that, so it didn't affect us much. Okay. And again, this is all going to be distributed to people. It'll be sent out on email. So, you don't have to write all this down right now. One last thing I want to say, because it happened a lot during the last foreclosure wave. Owners file for bankruptcy in order to stop the foreclosure, right? If an owner files for bankruptcy, federal law says there's automatically a stay of any court cases that are currently going against the owner, right? And that includes the foreclosure. It includes any case that you might have against them. And no new cases can be filed, right? So because the foreclosure case is stayed, the receiver loses all their authority. They are no longer in control of the building. They can't set foot in it. But in bankruptcy, something essentially the same as a receiver happens. In bankruptcy, the court appoints, they call it a trustee, to manage everything. So just to make everybody's life more difficult, if your landlord is in foreclosure and then they file for bankruptcy, you get, the faces change yet again. The receiver gets kicked out, a trustee comes along. Basically the same deal. It's their job to run the building. If the bankruptcy ends, then the trustee goes away, then you get the receiver back, etc. It can get complicated. But the key thing to know is that if the owner files for bankruptcy, yes, it stops the foreclosure. It sort of does another shift of the center of gravity, this time over into bankruptcy court. That's another hole for us to go down. In the event that happens, we're often able to get, big law firms that specialize in bankruptcy to come and represent tenants for free pro bono. They did a lot of that during the last foreclosure wave. We would hope that we could do that again. But anyway, we're not seeing any new bankruptcies come up in any of these portfolios yet. So we'll have to see how that plays out. Okay. So congratulations, you are all now lawyers and you can practice in Supreme Court. Or if you have any questions, now's the time.